Welcome to this video on navigating an O-1 visa crisis. Approved status, but the anchor job is canceled. We will unpack the agent-petitioner model, what happens when the primary engagement falls through, how the 60-day grace period applies, and the urgent steps to preserve status. We will also include a clear disclaimer that this is education only, not legal advice. Finally, we will summarize key takeaways and provide a checklist and diagrams to help you act quickly.
Let's dive in, and then transition to our agenda so you know what to expect.
Here is our roadmap. First, we will explain the O-1 agent model. Next, we will cover immediate cancellation and status risks. Then, we will discuss the 60-day grace period. After that, we will walk through an action plan and documentation. We will also address legal nuances and debates. We will include short quizzes along the way. Finally, we will summarize key takeaways and next steps. Now, let us transition to a short disclaimer. This presentation is for educational purposes only and does not constitute legal advice. Immigration situations are highly fact-specific. You should consult a qualified immigration attorney to receive advice tailored to your circumstances. With that clear, let us move on to understanding the O-1 agent model as our foundation. In the O-1B agent model, the agent serves as the petitioner and provides USCIS with an itinerary of engagements. The beneficiary is authorized to perform the work listed in that itinerary. Often, a primary or anchor engagement is critical to the approval, as it demonstrates the legitimacy, scope, and timing of the work. Even where the agent is not the direct employer, the petition from the agent is what confers the status. If there are material changes to the itinerary, including cancellations,
those changes typically must be reported to USCIS and may require an amended petition.
With that baseline in mind, let us transition to the immediate crisis scenario when the anchor engagement is canceled. When the anchor engagement listed in the approved petition is canceled right after approval, such as due to a reduction in force, you face an immediate status threat. Your O-1 status is technically held through the agent's petition, but the underlying basis, the work, has failed. This raises the controversial question of whether your status is instantly invalidated or whether it can be preserved while you replace the engagement. In either case, you should act immediately to document the change and move to cure it.
Next, we will discuss how the 60-day grace period can apply and when the clock starts.
The 60-day grace period allows certain non-immigrant workers, including O-1, up to 60 consecutive days, or until their current validity end date, whichever is shorter, after employment ceases. The conservative and safest interpretation here is that the clock starts when the petitioner, the agent, is formally notified that the engagement is canceled. Because the agent must maintain a valid itinerary and report material changes, prompt action is required. Do not wait until the last day. Instead, move quickly to line up a comparable replacement engagement and file an amendment as soon as it is ready. Now, let us weigh the core debate: whether status is invalidated instantly or effectively paused while you cure the defect. There are two competing views. View A is that when the anchor engagement disappears, the basis for status evaporates, creating immediate risk, potentially including accruing unlawful presence, unless quickly remedied by departure or status change.
View B is that because the agent remains the petitioner, the itinerary is curable by amendment, and the status can be preserved if the change is promptly addressed within the grace period. Practically, practitioners often advise a conservative approach. Act as if time is of the essence, and file an amendment as fast as possible, with strong documentation. Next, let us move into a concrete, step-by-step action plan. First, obtain written confirmation of the cancellation from the engagement. Second, work with your agent to prepare a material change notice and an amendment strategy. Third, source a comparable replacement engagement that fits your already approved category and scope. Fourth, secure a deal memo or contract with clear duties, dates, compensation, and deliverables. Fifth, assemble updated evidence, including the revised itinerary, expert letters if appropriate, press, awards, and comparable evidence to show continued extraordinary ability and qualifying work. Sixth, draft and file the amended petition through the agent as soon as it is complete. Seventh, maintain continuity by avoiding any unauthorized work and documenting every action. Eighth, if you cannot finalize and file by approximately day 60, Consult counsel to evaluate alternatives such as a change of status, a consular filing plan, or a timely departure to preserve options. Next, we will support this with a simple timeline checklist table. This table provides a concise timeline checklist. In days 0 to 5, confirm the facts and establish a plan, producing written cancellation, an advisory memo from counsel, and a document inventory. During days 6 through 30, secure the replacement engagement and update the itinerary, producing a draft deal memo. Days 31 through 45 should focus on preparing the filing, including a final contract, forms, letters, and exhibits. Days 46 through 60 should culminate in filing the amended petition or executing an alternative strategy, such as a change of status or planned departure. Now, let us test your understanding with a short quiz. Question: when does the safest interpretation say the 60-day grace period begins in this scenario? Options: A. On the original petition approval date. B. When the agent is formally notified that the anchor engagement is canceled. C. When the beneficiary personally learns of the cancellation. D. When a new deal memo is signed. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. The safest and most conservative interpretation is that the clock begins when the petitioner, the agent, is formally notified that the engagement has been canceled. This aligns with the agent's responsibility to maintain the itinerary and report material changes. Now, let us move to a second quiz question about who is responsible for amending the petition. Question: who is responsible for filing the amended O-1 petition to substitute the canceled engagement? Options: A. The beneficiary directly. B. The agent or petitioner. C. The canceled employer. D. USCIS, upon notification. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. In the agent model, the agent is the petitioner and is responsible for maintaining the itinerary and filing any necessary amendments. The beneficiary should assist with evidence, but the agent must file. Next, we will cover some legal nuances and practical interpretations, with a bit of markdown to emphasize key points. A few legal nuances bear emphasis. First, on the definition of employment ceasing. In this scenario, treat the date the agent is formally notified as the trigger, because the agent is the petitioner and controls the itinerary. Second, anchor cancellation is a material change that requires action from the agent, typically a notification and an amended petition. Third, document everything. Save emails, letters, drafts, deal memos, and even shipping receipts and tracking numbers. As a practical tip, organize your materials with clear folders and a running log of dates, contacts, and filings. Next, we will visualize the stakeholders and steps with a Mindmap style diagram to reinforce the workflow. This Mindmap centers on O-1 crisis response. From the center, we branch to the agent, the beneficiary, USCIS, counsel, and engagements. Under agent, we include notifying USCIS of the material change, amending the itinerary, and filing the amendment. Under beneficiary, we include sourcing a new engagement, securing a deal memo, and providing evidence for the amendment. Under USCIS, we show receiving the amended filing and adjudication. Under counsel, we include strategy, compliance review, and documentation planning. Under engagements, we show the anchor cancellation, a replacement that is comparable in scope and category, and clear terms and dates. We also align tasks to time windows. Days 0 to 5 for confirmation and planning, days 6 to 30 for sourcing the replacement, and days 31 to 60 for finalization and filing. Next, we will highlight key points you should remember. Remember these points. The agent is the petitioner and must maintain and amend the itinerary. Anchor cancellation is a material change, and you should act immediately. The safest trigger for the 60-day clock is the date the agent is notified. Do not wait until the deadline. File the amendment as soon as it is ready. Document everything to preserve status credibility. If filing is not feasible by approximately day 60, work with counsel to consider alternative strategies. Now, let us summarize and close with next steps and a call to action. In summary, confirm the cancellation in writing and treat that as the trigger for the grace period. Line up a comparable replacement engagement and secure a deal memo as quickly as possible.
Work with your agent to file an amended petition with strong evidence. Use a documented timeline and checklist to stay organized. Finally, engage qualified counsel for advice tailored to your specific facts. As we wrap up, we will close with a thank you and a call to like, share, subscribe, and comment. Thank you for watching. If this video was helpful, please like, share, and subscribe. Share your experiences and questions in the comments. Your insights could help others facing the same challenge. We appreciate your support and look forward to hearing your thoughts.